Yo, it's JP. Let's talk about disability discrimination. Okay, let's start here with why it matters. Number one, at a very brass tacks reality level, everybody's got to eat. Everybody's got to pay the bills. Everybody's got to make a living. And folks who have disabilities, folks who have different health conditions, that applies to them too. Okay? They got to make a living. They got to pay the rent. They got to survive. They got to have a job. All right. And at a philosophical level, at an ethical, moral level, life's got to be hard enough already. Life's hard enough already for everybody. Okay. It's got to be even harder for folks who have disabilities, who have health conditions. And there are many people who have disabilities, who have health conditions, who can make a tremendous contribution to a company, to the workplace, to a mission, to a vision. And all they need to facilitate that is just a small accommodation, a small adjustment that will allow them to make a meaningful contribution. So as a society, we have to value this. Right? As a society, we have to look at this and say, yeah, everybody's got to make a living. And that includes disabled folks. That includes people with health conditions. And we should be willing to give them a small accommodation in order to facilitate their full involvement in society, in the workforce, etc. Right? That is on the side of what is good. That is on the side of humanity. And I am always and ultimately on the side of humanity, because there are sides here. You pick a side, okay? And this is the side that I picked, all right? So that's the why. That's the why. Now let's get into the law, all right? Number one, it's got to be a covered employer. It's got to be a covered employer. At the federal level, the Americans with Disabilities Act, the ADA, only applies to companies or employers, right, including the government, if they have at least 15 employees. If they have less than 15 employees, not covered at the federal level. Now, certain states, even certain cities, have a lower threshold in terms of the employee head count, where you do have protections against disability discrimination. But let's be real about that, all right? I litigate these types of cases. I accept these types of cases. We pursue these types of cases throughout the country. And I'm just going to be real with you. I am not interested in pursuing disability discrimination cases or any discrimination cases against small companies, because the juice is just not worth the squeeze. The money is just not there. Okay? At the end of the day, these are contingency fee cases. And so for us on this side, right, whether it's me, whether it's you, whether it's both of us, right, for us to get any meaningful recovery here, there have to be assets, there have to be resources. The other side has to have money that we can go out there and get. And if it's a 15 or a 20 or a 30 person company, okay, the odds are that in many instances, the juice is not going to be worth the squeeze. So you got to make sure there's coverage. And in all likelihood, unless there are at least, 50, 60, 70, 100 employees at a company, I'm probably not going to be inclined to take that sort of case, because I've gone through this before. There are a lot of law firms that do plaintiff side employment work that are just settlement mills, and they either just want to write a demand letter, or not even write a demand letter. They just want to go through the EEOC process, do a free EEOC mediation, and settle the case for 5 or 10 grand. That's not what I do. That's not what I do. Yeah, is that meaningful for some people? Sure it is. And if that's what you want, there are plenty of other lawyers who will go get that for you. That's not what I do. We take cases where, candidly, every case has its own valuation. Every case has its own assessment. Every case turns on its own facts. But when we pursue these cases in litigation, I'm not pursuing these cases to get 50 grand, 100 grand, 150 grand, 200 grand. I'm not pursuing these cases to get anything less than 250, 300 grand a pop as kind of a floor in terms of the types of cases that I select and that I pursue and that I put all the time and resources into. And so the bottom line there is, if it's not a company of a certain size, it's just not going to be worth all the time and the money and the effort. And if it's a company that has less than 15 employees, it's not going to be covered at all by federal law. Okay, so that's the coverage piece of it. Number two, all right, is the person qualified for the job? Are you qualified for the position in question? What is the single most significant indicator that a person is qualified for a particular job? Prior favorable performance in that particular job. Okay, so if the person's qualification never comes up or is in dispute, well, the fact that the person did the job and got favorable reviews, got promotions, got raises, was spoken highly of in the position for 5 or 6 years, that is the most compelling indicator that the person is qualified for the job and can perform the job. And I know that sounds kind of preposterous, but we get into these sorts of cases where a person's with a company for 5, 6, 7 years, they ask for a certain accommodation, and then all of a sudden the company starts having issues or taking issue with their performance, right? They go from being a star performer for several years, great track record, then the second they ask for an accommodation, all of a sudden it becomes, Joe just sucked at this job. He just sucked at this job, Pay no attention to the past 7 years. He just sucked at this job the whole time. So you have to be qualified for the position, okay? You have to be qualified for the position. Number three, disabled or perceived as disabled. I can't believe we have to explain this, but apparently there are not just companies who don't understand this, there are judges out there who don't understand this, okay? You can either have a disability or the company perceives you as being disabled. I'm going to blow your mind, folks, okay? We have a case right now that's up on appeal, okay? It's in a federal appellate court right now, where the trial court judge said it wasn't clear that a person having a brain tumor qualified as a disability. It's not clear that somebody having a brain tumor qualifies as a disability. Well, let's table that, okay? The fact that the company or the employer considered the person disabled, the fact that the company looked at the person and said, you have a brain tumor. We don't think you can really give this job 100% because of your brain tumor. That qualifies for protection under the ADA because the person was perceived as being disabled. That's the whole point of the law, right? Is that this person can do the job. They can do the work. They can perform up to the level. But the company or the employer assumes that they can't do the work because of the disability. That is disability discrimination. So it can be either a disability or it can be a perceived disability. Okay? Number four, reasonable accommodation. Reasonable accommodation. Okay? What is reasonable? That's the ultimate fact-intensive question. What is reasonable as an accommodation depends on all of the facts and circumstances. And I will tell you this, most significantly, the size of the company plays a tremendous role in what constitutes a reasonable accommodation. And this goes back to my earlier point about coverage and about taking cases in this arena where the company has more employees, where the company that's a bit larger of a company, right? Because what's a reasonable accommodation for a company with 20 or 30 employees is going to look a lot different than what is a reasonable accommodation for a company with 500 employees, 1,000 employees, 10,000 employees, 50,000 employees. So if you're a person who's watching this video and you think you might have a disability discrimination claim, in terms of realistically assessing the strength or the viability of the claim, one of the things you have to consider is how big is your company? How big is your employer? And just think about it, because this makes sense, right? If a company has thousands and thousands of employees. The company's bigger, the company's more sophisticated, they have more resources, they have more positions, okay? They have more flexibility at that size and at that scale. And so the odds are they are more able to accommodate some changes. The odds are that they're more able to accommodate a different schedule, somebody working from home certain days, somebody even switching positions, right? Changing positions within the company can even be a reasonable accommodation, okay? But it's a very factually intensive question, okay? I've seen reasonable accommodation cases that involve changing a position, occasionally working from home, somebody requesting special software that helped them because they had visual impairment. I've had reasonable accommodation cases where people requested sort of quieter working environment because of certain auditory conditions. There's all sorts of things that can constitute a reasonable accommodation, but it all comes down to the facts and circumstances, the size of the company, the resources of the company, okay? At the end of the day, I actually think disability discrimination cases are easier to prove than a lot of other types of discrimination. Why do I say that? Well, in disability discrimination cases, there's no hiding the ball, okay? There's no hiding the ball, right? The real fight is over whether or not the person was qualified to do the job and whether or not there's a reasonable accommodation available, all right? There's no smoke and mirrors there in terms of this is about a person who has a disability or a health condition. They wanted this accommodation. The company says they can't honor that accommodation, and that's where the central fight is, okay? In other discrimination cases, okay, race discrimination, age discrimination, the central fight is less clearly admitted, articulated, and recognized. And by that I mean in so many other discrimination cases, race discrimination, age discrimination, sex discrimination, you have the plaintiff or the employee alleging that they're being discriminated against, okay, on the basis of race, age, religion, sex, whatever, okay, over here. And then you have the company over here saying, no, this has nothing to do with that. This has nothing to do with that. Joe was a terrible employee. Here's these bogus performance reviews. Here's the reasons why we fired him. It was about X, Y, Z, all these other things, right? So there's just more layers of subterfuge and shenanigans in those other categories of discrimination cases than there are in disability discrimination cases. And that's not to say that there is never any subterfuge. Of course there is, okay? Of course there is. I've seen companies come in, and like I said earlier in this video, they'll say that a person is not qualified when they've done the job successfully for 5 or 6 years. Companies will come in and say, oh, there wasn't another accommodation, there wasn't another position, there wasn't a reasonable accommodation, we couldn't grant that, it would have been detrimental to the company's bottom line, et cetera, et cetera. Sure, there will be shenanigans on that front and in that direction, but at least in disability discrimination cases, the central fight is clearly defined, as opposed to in, say, a race discrimination or an age discrimination case where you have, multiple fronts going on, right? Where here you have the discrimination fight, and it's like, hey, this was discrimination, we're proving discrimination. And over here, you got a whole other sideshow about, okay, we fired the person for performance, we fired the person for insubordination, we fired the person for negligence, et cetera, et cetera. In disability discrimination, the fight is more centrally admitted and understood. So I find these cases a bit easier to succeed in. than many of the other types of discrimination cases. If you have a disability discrimination case, if you think you might have a disability discrimination case, you are welcome to reach out to our firm. We take these cases nationwide. Jonathan Pollard, happy Tuesday.